Guys, it's Kathy. I hope you're doing well. Alright, I honestly can't remember where we're at. Oh, I remember now. So, the defendant, Michael, his lawyer is now questioning someone on the stand about, I don't know, the stupidest things. Politics and why are police looking at a crime, and you know, why are milkmen delivering milk, and why do they deliver it to Michael's house when they haven't delivered it to Michael's house in years? uh, Also, paperwork. You know, paperwork is hard. That doesn't mean it's fraud. It doesn't mean it's fraud if you fill out all of your paperwork completely wrong on purpose for the purposes of hiding all of your income so you don't have to pay any child support. That's not a crime. It's just someone being stupid. No, we don't have milkmen, unfortunately. Oh, because he needs some milk for the children he's not allowed to see right now because of her. It's all her fault. Alright. The State of Nevada versus Mike McDonald Part 5. And this has 7 parts, correct? 6 parts. So, we have a 2-hour video today, and then tomorrow we get to the end of this one. And then we move right on to the next one.
Did you send a, if you will, final draft to?
Your Honor, unfortunately, I haven't been able to get my laptop to connect to the internet, but I have a USB that I can save it to, and then we can write it up from there.
If you have a USB, you can give it to thumb drive, right? You're talking?
Yes.
Yes, sir.
And I would assume you could give it to IJ to print out. Why don't you get her to print? And you've reviewed that, I
Yes, sir.
assume? Okay, so print that out. We'll go through it. Well, give it to Steve. All right, so as to this proposed or change, it's the defense, so go ahead.
Your Honor, thank you. State is alleging several specific intent crimes. This is very unusual. Specific intent crimes are usually pretty obvious. I punch somebody, I hit somebody, I take a gunshot at them, try to run them over with a car, try to kill them. That's specific intent. State's allegations here are noticeably less clear and concise. And Mr. McDonald intentionally filed documents wrong, and rather than documents were simply incorrect. The state cannot come in here and say, these documents are wrong, therefore Mr. McDonald's committed a crime. That's not the law. He's got to specifically intend to file false documents to get for his perjury, and the filing of false documents to resist. And that's one of the law that needs to be clarified very clearly to the jury. Now, this is particularly troubling to this officer of the court, and I've said in openings there, I've said several times, family court is one place where you absolutely don't have any choice. You can be litigated by anybody, and if you run out of money, you're litigating by yourself. Now, if you don't understand how to do it, or if you're not a very sophisticated
You
person.
can make that argument. What I want to know is, and you provided me with the Supreme Court case, the issue is, should there be a explanation that, and I assume, I haven't seen, or haven't gone through the entirety of the proposed jury instructions, but you want to amend this jury instruction to add the following, and I'll read it, so it's, I'll read the whole thing. Ignorance of the law is no excuse. Everyone is conclusively presumed to know the law, and one accused of a crime is precluded from using as a defense his ignorance of the law. Thus, when the evidence shows that a person voluntarily did that which the law declares to be a crime, it is no defense that he or she, but he did not know that his act was unlawful or that he believed it to be lawful. Then you want to add, however, where the specific intent to commit a crime or willful conduct are required, ignorance of the law can prevent the required specific intent or willful conduct from being present. Correct. Correct?
Yes, sir.
Okay. So your argument that there are several specific intent crimes alleged, and you want to add that wording pursuant to Rebuttal, I don't know how you pronounce that. Rebuttal, United States, it's Supreme Court for the record, 114, Supreme Court 655. Anything else?
No, Your Honor, and this is unusual in that this is Mr. McDonald who's doing obligations imposed by him as law. The vast majority of criminal cases are just prohibited from this offense. In this instance, the state is unsatisfied with the way he executed his duties by being hauled into family court, which I believe should give him a specific intent instruction.
Well, don't we have a specific intent instruction?
Or I should say ignorance of the law instructions.
Okay, is there a specific intent instruction?
Defining specific intent, no.
Yeah. These are specific intent, or there are some specific intent counts, correct?
Yes, Your Honor.
And we need a definition of specific intent. All right, as to this instruction, go ahead.
Your Honor, I guess first I should ask, would a specific intent instruction kind of take care of the argument that we're arguing right now?
Probably. I don't know why there isn't one.
If that would remedy this argument, I think that's what we can agree to.
These, nobody disagrees these are specifics. There are several specific intent crimes, and yet, I granted you've been busy, all of that. Nobody put in a specific intent instruction. Crickets.
Again, I will make a record, Your Honor. This has already been said on the record, but our instructions were sent many days ago to yourself and to defense counsel. He made a record this morning that he was okay with every instruction except this one, even though he said that the standard instructions that are used in generally every case in the courthouse are accepted by him, except apparently this one because it doesn't fit with his theory of the case.
There is a specific intent instruction. My problem, and I'll let you address this addition. Well, first of all, if we put in a specific intent instruction, are you okay with that as opposed to this sentence, or is it one sentence? And second of all, I guess my question is, are required, it's not necessarily you have your ignorance of the law can prevent the required specific intent or willful conduct from being present. Well, I suppose that, that's like saying if he, in any crime, if he didn't do it, then you can let him go. The case that you cited, which I have in front of me says, and this is appropriate, you're correct. There has to be knowledge of the requirement, if you will, and this is under, and it seems to be very specific to the case. It's regarding the reporting requirement anytime a transaction with a bank is done for more than $10,000 or more. And so they go through a lot to discuss that the legislature put in the willful part. And therefore, and let me quote it, that he or she, but it was a he in this case, voluntarily and intentionally violated that known legal duty. Knew the structure in which he engaged was unlawful. And they go through and explain what this structuring is. In other words, and so it's clear, they talked about a case where somebody was making $9,500 deposits on a regular basis, and they said that that wasn't necessarily, well, it may have been structuring, but it wasn't willful. So they said a jury instruction, the jury had to find he knew the structuring in which he engaged was unlawful.
That's the link to Debbie's page that Kelly's talking about, that doozy of a case. Thank you, Debbie.
The word willful, and again quoting from the case, word willful means no more than that the person charged with the duty knows what he is doing, not that he must suppose that he is breaking the law. That may have been, let me check, there's an extensive, well, that's what the minority said. Mr. Oh man, I get, they're both M's. Mr. Mueller.
Yes.
If we put in an instruction from the standard instructions regarding willful, are you okay with that as opposed to this?
I certainly am open to that, Judge. I don't have it for me.
Look, I don't see where. I don't have what I know of, willful. Does the state have one?
And Your Honor, if I could connect to the internet, I could find one very quickly.
I can't help you with that.
I know. That's beyond your job.
Was it in your original packet?
No, Your Honor, but we do have a standard jury instruction, I know, but I would need to connect to the internet to. But we could probably go grab one and get
If you give me about 5 minutes, I can go throw one out.
Go grab one.
Okay.
Thanks, Brandon.
Yeah.
And you guys better tell them it's gonna take a half hour because we still gotta get them printed out.
I've already told them that court had already started
Okay.
outside of their presence.
And so they said, and since I'm a firm believer with sticking with quotes from the cases, he said he does have to find, if it's willful, and the statute, and again, nobody has actually quoted the statute, but I assume the statute includes the language, the specific language, that the conduct has to be willful, because that's exactly what we're talking about in the Ratzlaff case. They were, I'll quote that statute, a person willfully violated this chapter, ... goes on to explain. So Sandy gave you a final draft. We're not talking about this particular one, but just the ones that you agreed on. And did you have a chance to look to make sure there's no more mistakes?
Yes, Your Honor. At this point, there aren't any that I see.
Defense?
And I don't see any mistakes, right?
Okay, so did you find what do you have?
I have a standard
Did you give it?
instruction. I had it emailed to your JEA as well, Your Honor. I showed it to defense. He doesn't have a problem with it.
Okay, so when you say, Mr. Mueller, what you don't have a problem, or he's saying you say you don't, does that mean that that is adequate as opposed to your red line here?
No, Your Honor, their instruction is a definition of specific intent. I agree with it, I'm open to it, I think it's a good idea that we add it. I do not, however, in any way, shape, or form removes a requirement or request that the addition of constitutional language is added to the subsequent instruction.
All right, let me see the instruction. Okay. So this one, you're both agreeable to.
State's understanding is that would be in lieu of the addition to the other expression.
I say or suggest if rather in lieu of, it should be in addition to. And that I would propose that the new specific intent definition instruction be added, it should be added directly in front of the one that we propose to have appended, and then they both go back to the jury.
All right, so here's the thing I have. However, with a specific intent to commit a crime or willful conduct or required. I would suggest we use the language out of the case, which says, for, or adapting it to this, specifically what they said, which is,
Which case are you referring to?
rat slap. Do you want a copy of it? The U.S. Supreme Court case?
Right. And
They don't do what you did, which is saying more or less, basically, this would be exactly what the opposite of what the minority says. They specifically, pretty much, anyway, the point is,
haven't missed
says,
anything.
have voluntarily and intentionally violated that known legal duty. And in RASIP, we're talking about the duty to report. But that's,
Very specific to a niche argument, Your Honor. Kind of what you went through, that Supreme Court case involves bank standards, antitrust laws.
I get that, but it certainly applies here that he has to, because we have the same willfulness in there, that he have voluntarily and intentionally violated that known legal duty, or in this case, the known legal duty.
Correct. The last paragraph, Your Honor, I don't have the line because it's from my phone, but they say, in particular contexts, however, Congress may decree otherwise, meaning that in the first sentence, we do not dishonor the venerable principle that ignorance of the law generally is no defense to the criminal charge. In particular context, however, meaning this very specific niche argument and the context under Ratzlaff, which has some tenable similarities to our case, but nothing close to what is mentioned there.
Well, the statute itself, the statute we're talking about, are willful violations, virtually the same. Well, the willful, the legislature here in Nevada put willful, and what the Supreme Court is saying is that willful is not to be ignored.
That
So,
is correct, Your Honor. It just doesn't mean that a specific, in all specific intent crimes, that the person must have the specific intent to commit a crime and that ignorance of the law can be a defense. There's case law regarding burglary as a specific intent crime, and there's case law stating that a person can still commit burglary even if they don't realize that what they're doing are in fact felonies. So, and the state is being kind of blindsided because the state submitted its jury instructions to the defense about a week ago, and now shortly before closing, we're...
believe me, I'm not thrilled. I asked both sides, and certainly you've had no opportunity to do any research on it.
I know you have the case in front of you, Your Honor, and you're aware that there's multiple very strongly worded dissents. I would point out the last paragraph of the last dissent. The majority's interpretation of the anti-structuring provision, that's a very specific provision that deals with that case, not ours, is at odds with the statutory text, the intent of Congress, and the fundamental principle that knowledge of illegality is not required for a criminal act. Now Congress must try again to fill a hole it rightly felt that it filled before. So again, they're saying this goes against everything in history, specifically for that case.
And your specific, or your both specific and general intent instruction come from a 2005 Nevada Supreme Court case. Bolden, are you familiar with that, Mr. Miller?
Yes, generally, Judge, I try to read everything that comes out, but a lot of it doesn't stick, I'm not gonna lie.
I freely admit that in 2005 I wasn't doing criminal, so I didn't read it. But this, you're familiar with this, and you don't disagree, I guess, with this particular one?
Yes, Judge, I do not disagree that
Which does
we
define
need
both
specific.
specific and general.
Yes. What is the context of this?
With the non prohibit.
Now,
Give me a minute, as I said, I like to be informed. I'm going to read Bolton. You know, it's... I apologize, maybe I'm overly cautious because I've only been doing this a year, but I do read everything, so I can make my best effort to get it right. I'm sure that won't, I'm sure there will be different opinions someday from higher courts, but hopefully I got most of it. All right. Anybody have anything else to add?
no, Your Honor, I think you've been very thorough.
No, Your Honor.
Tried. All right. I read Bolton which is a Nevada Supreme Court case on the issue. And so it's clear, oh, here it is, okay. It's a 2005 case, so it's clearly almost 10 years after the U.S. Supreme Court case, and it discusses specific and general intent rather thoroughly. It's clearly the subject of that case, although they do mention Batson, surprisingly, but that was a different issue, of course. So I am going to give the definition. Specific intent is intent to accomplish its precise act, etc. And then general intent. I think that covers and defines what we have in this case. I certainly am not disagreeing with the U.S. Supreme Court in Ratzliff, but they clearly went out of their way to talk about the fact that that was a rather obscure, if you will, crime that in fact had to be explained, because they go into everything from the very beginning to explain that the defendant had to be told that had a way to get around the reporting limits of $10,000. And coincidentally, it's a Nevada case. But in any event, so the casino was telling this individual how to do it, etc. And the Supreme Court said how this, or the facts, were very specific to the case. This isn't, you can't shoot somebody. This is, you can't do a $10,000 transaction where you're taking cash and converting it, etc. And so I don't think, and even they say, and I'm talking the majority, that it doesn't change the fact that ignorance is no excuse. Ignorance of the law is no excuse. So I'm giving this, which we need to be put in without the cite, I'm giving the ignorance. I'm not adding that language. And so I will, although I don't have a clean copy, I will sign it and submit it. Does anybody have a clean copy of your proposal? I have some, I don't know if you, I know it's not mine, wrote the U.S. Supreme Court case on it. And there's a little known rule that I have to sign any jury instruction that I reject. And I can tell nobody knows that, and it was told to me by Dan Polsenberg, and I looked it up, and he was absolutely correct.
Yeah, Your Honor, we were pretty pressed for time last night. We got hit with a lot of stuff we had expected. There's no clean copy.
All right, then I'll sign this one. It'll be a court's exhibit.
I think, Your Honor, and for the record, you did were very thorough, and I appreciate the court taking their time. I do object for the record. I believe
Absolutely.
I do believe this case is much closer to the Ratliff than the federal line of cases, and that instruction should be given.
And this is a defense instruction.
Defense proposed, correct.
And it's from, of course, exhibit in section 5.
What's that?
It's a 5.
Yeah. And do you, I assume, have that other, without the defendants proposed in here, in this packet?
That was emailed to the JDAs, your JDA, so she should be able to add it. Because it was in the original packet.
Oh, here, it's here.
Oh,
It's in this packet. All right, so let's start off with the verdict form. We discussed that on the record, and the defense did object that they wanted clarification for each of the counts. I don't think that's necessary. In fact, I think it is, as I said, confusing. So I am going to give this verdict form. Now, instructions. Hopefully, you have copies, because I'm going to go through and read a small portion, and then it'll be numbered. Does everybody have a copy?
Yes, sir.
yes, sir.
Okay. And instructions to the jury is number 1. If in these instructions any rule is number 2.
Okay, got it.
And indictment is number 3. And that is several pages. Then the next, to constitute the crime charged, is number 4. And if I
Speaking of crimes, chat, what's going on? What are you doing? I think y'all need to rethink your life choices right now. Just stop. And there comes Brennan with the slam dunk of it all. Stop.
don't have a right or whatever, stop me right away, tell me. The defendant is presumed innocent, is 6. 5.
We don't eat that, Bren. All that stuff they're typing, we don't eat that.
You are here to determine is now 6. The evidence which you are to consider is 7. And by the way, stop me when you think this specific intent should be inserted, or you can, if you want to take a second and discuss that amongst yourselves. The credibility or believability is 8. We're still not even into that type of a thing. A witness who has special knowledge, skill, number 9. It is the constitutional right of the defendant, is 10.
And Your Honor, the statements after that would be a good place for the specific intent instruction.
After that, we get into the actual crime charge.
Which is defense.
Oh, I don't have an opinion, Judge.
Okay, then, Alright, is the start of the definitions for the crime, so that'll be 11. And we need the one without the site. It's 11 now, it's the one on specific intent is the intent to accomplish. So,
Anybody just walking in, I promise you, you have not missed anything.
any person who by day or night is 12. You are instructed that forgery is 13. It is not necessary that the state prove is 14. What's that?
Never mind now.
The intention with which...
Let's talk for a second, guys. He's going over the jury instructions. And then he's going to read each jury instruction to the jury for approximately another hour. We can skip that hour, go long today, and finish today if we skip that hour. What do you think? Yep, me too. Thanks, guys. Glad you're on my side. I have the link in my description if you would love to hear the jury instructions. Now, on to closing arguments.
Whatever counsel may say, you will bear in mind that it is your duty to be governed in your deliberations by the evidence as you understand it and remember it to be, and by the law as given to you in these instructions, with the sole, fixed, and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. State.
Thank you, Your Honor. Ladies and gentlemen, the evidence shows that on September 27, 2017, the defendant, Michael McDonald, filed in family court a copy of the letter that his therapist, Nancy Hunterton, wrote for him. And had he stopped there, he would have committed no crime and we wouldn't be here today. But the defendant didn't stop there. Instead of going back to Ms. Hunterton, his therapist, and obtaining a more detailed letter outlining the conditions that Ms. Hunterton felt would allow him to see his children, but ensure the safety of everyone, instead, the defendant took matters into his own hands. And he took the letter that Ms. Hunterton wrote for him, and he added a sentence. I do not believe that Mr. McDonald is a danger to himself or to others. He took that into his own hands, he altered that letter, and then he filed it in his family court case on 3 separate occasions, committing multiple offenses. He filed it on December 4th of 2017, he filed it on March 13th of 2018, and he filed it on March 21st of 2018. When he filed it on March 13th of 2018, he filed it as part of an exhibit list. And in that exhibit list, there was also his general financial disclosure form, in which he claimed, thereby perjuring himself, that he was unemployed and had approximately $800 of income each month, when in reality, he had a salaried position as a systems administrator. And then a few days later, March 16th of 2018, he testifies at his family court hearing, the hearing for which that exhibit list was filed, and he perjures himself again. And he testifies again that he has no employment other than odd jobs, that his income is essentially $800 a month, when in reality, each of his paychecks is over $1,800. Now, in every criminal case, the state is required to prove 2 things. What crimes were committed and that the defendant is the person who committed those crimes. In other words, what happened and who did it. And I'm actually going to address number 2 first, just who. And I'm not going to belabor the fact because, for lack of a better word, ladies and gentlemen, this isn't really a whodunit. This isn't something like a robbery where it's an identity case and someone needs to pick somebody out of the lineup. At this point, the evidence has shown that it's the defendant's conduct that brings us into court today. You heard testimony from Christina O'Connor, who works at the family court clerk's office. She testified that all of the pleadings in this case were filed at customer service counter. The December 4th, 2017 pleading was filed in this building, in the district court clerk's office. And the pleadings filed on March 13th of 2018 and March 21st of 2018 were filed at the family court clerk's office. You heard testimony from Brett Zagaski, the marshal who works in this building, and he testified that he saw the defendant on the surveillance video from this building. And when? On December 4th of 2017. That's the date that the defendant first filed the forged letter in his family court case. You also heard testimony from another marshal, Timothy Spees. He testified that he saw the defendant, Michael McDonald, in the filing room of the Family Court Center on March 13th of 2018. It's called the reading room, but as you heard him testify, that's where people go to file their family court documents. That's the same day that he filed his exhibit list. There's the date, and there's his name in the upper left corner. Now, you also heard some testimony from Detective Aaron Stanton about executing the search warrant at the defendant's home. And there was a lot of evidence recovered and photographed in the execution of that search warrant. And the defendant actually assisted Detective Stanton in finding a lot of this evidence. The defendant initially told Detective Stanton that there was probably a photograph of the letter that was on his phone, but it had been deleted, and said that it would be on his Google Drive. The defendant pulled this document up himself. And that's the altered letter on the left. I'm sorry, that's the altered letter on the right. That's the original letter on the left. There's the additional sentence. I do not believe Mr. McDonald is a danger to others or himself. So both versions of the letter are on the defendant's computer. The defendant is the person who pulled these items up. So at this point, there should really be no question it's the defendant's conduct that we're concerned with today. And what else was found in the search warrant? A binder containing the letter. And that's a copy of one of the court pleadings filed December 4th of 2017, found in the defendant's home. And inside of that was a copy of the forged letter. There's a copy of one of the pleadings that the defendant filed March 21st of 2018. Again, containing a copy of the forged letter from this case. So the defendant is seen in the Regional Justice Center, this building, on December 4th of 2017. He's seen in the family court reading room where people file family court documents on March 13th of 2018. His name and signature is all over these documents, and all of the admitted documents and videos and everything that was admitted as exhibits you'll have with you to review for yourself when you're in your deliberations. There's the defendant's signature again, March 21st, 2018. There's his name. It's on the upper left corner of all of these documents that he filed. Further, the defendant admitted to Detective Stanton that he filed the documents. He never said, wait, what are you talking about? I don't have a family court case. And he admitted it right away when Detective Stanton came to talk to him. He talked to him about his family court case, all of the issues that he was having. He wasn't in denial. On March 16th of 2018, you saw the video of that hearing in which the defendant testified. He stated that he filed the exhibit list, the one that was filed March 13th of 2018, that contained both the financial disclosure form as well as a copy of the forged letter. That's him being sworn in, March 16th of 2018. Now, I want to bring your attention to one of your jury instructions, which tells you that you can use your common sense, your everyday common sense and judgment as reasonable people. You're not limited solely to testimony. You're permitted to draw reasonable inferences from the evidence based on your everyday common knowledge. Now, I'm going to move on to talking about what crimes the defendant is charged with. And this is actually the order I'm going to talk about them in, which I apologize is kind of a different order from what's in your copy of the indictment and the jury instructions, but I think this will make the most sense to you when I explain the elements of these offenses. So the defendant is charged with three counts of forgery, 3 counts of offering false instrument for filing a record, 3 counts of burglary, and 2 counts of perjury. So I want to address the forgery first. And as one of your jury instructions tells you, any person who falsely makes, alters, forges, or counterfeits any record or any document or paper recorded in or filed in any court with the intent to damage or defraud any person or persons is guilty of forgery. So you actually have 3 different forgery instructions in your packet because there are 3 different ways that the defendant committed forgery in this case. Okay? And that's why your indictment is so long, because it lists all of the different ways. Another way you can commit forgery: any person who passes or attempts to pass as true and genuine any false, altered, or forged record or any document or paper recorded or filed in any court, knowing it to be altered, forged, or counterfeited with the intent to prejudice, damage, or defraud any person is guilty of forgery. And finally, a person who, with intent to injure or defraud, makes any false entry in any public record or account is guilty of forgery. Now, I submit to you that the state has proven beyond a reasonable doubt that the defendant committed forgery under all 3 of these definitions. But in your deliberations, some of you might disagree. Some of you might feel that what he did was actually altering the letter. Or some of you might feel he did all 3. Some of you might believe that he only did the second version, which is passing off a forged letter as genuine to the court. And it's okay if you disagree, as long as if you all are unanimous and agree that he committed forgery, regardless of which version of forgery he committed, then you can find him guilty on that count. But I want to go through these and explain how he's actually guilty of all 3 versions. So there's the alteration of the document that he filed. When the defendant did that, he was committing forgery. When each time he filed the document and passed off that altered document as genuine, he was committing forgery. So on December 4th of 2017, March 13th of 2018, and March 21st of 2018, each time he was committing forgery simply by going to the court and representing that this document was true and accurate, that this letter that Nancy Hunterton had her signature on was actually her letter. And by doing so, he made a false entry into the public record of his family court case. So December 4th of 2017, the defendant takes this document. It contains this forged letter. The red section is the forgery. And I want to emphasize this a little bit because there was some insinuation in the questioning throughout this case that this document isn't really forged because maybe the sentence itself is somewhat accurate. But the falsity of this letter is that the defendant is representing it as the letter that Nancy Hunterton wrote. It's not. She didn't write this letter. The one she wrote did not have the sentence in it that's underlined in red. So by representing that this letter is what Nancy Hunterton said, the defendant was committing forgery. He was passing off this altered document as genuine when it is not. And you heard testimony from Ms. Hunterton that even if she had written another letter, it wouldn't have exactly said this in the first place. But regardless, these are not Nancy Hunterton's words. Okay, this is not the letter that she wrote. It's an altered and forged version of it. The defendant passed this off as the letter written by his therapist when it was not. Okay, that's the deceit, that's the forgery. This is the letter that Nancy Hunterton wrote that doesn't have that sentence in it. So this is the genuine letter. This is the false letter. And so the defendant
committed this crime, as I said, on 3 occasions: December 4th, 2017, March 13th of 2018, and March 21st of 2018. Each time that he passed off this altered letter as genuine, he was committing forgery. And the last requirement of forgery I want to talk about is intent to defraud. So defraud really just means to lie or deceive. And what was the deception here? He was passing off this letter as something that Nancy Hunterton wrote. She didn't write it. She wrote a letter. As soon as the defendant added that additional sentence that she didn't write, it became a forged letter. It was altered. It was no longer true. What he submitted to the court was a complete forgery. Now, offering false instrument for filing a record, this is a somewhat simpler crime compared to forgery. There's no intent to defraud here. The definition here is any person who knowingly procures or offers any false or forged instrument to be filed, registered, or recorded in any public office, which instrument, if genuine, might be filed, registered, or recorded in a public office under any laws of this state or the United States, is guilty of offering a false statement for filing a record. And that's really just a ridiculously long way of saying whenever you file something in a court or other type of recording office that's false and you know it's false, you're committing this crime. And similar to the forgery, he committed this crime on 3 different occasions: December 4th, March 13th, and March 21st. Every time he filed that forged letter, he was committing this crime of offering false instrument for filing a record. This letter right here. Now, I want to talk about the burglary now. And I know some of the more curious among you have probably been wondering why he's charged with burglary. Because I know kind of the common layperson way we talk about burglary is typically when somebody breaks into your house, they're committing burglary. But in Nevada, that's actually not the only way you can commit a burglary. The actual legal definition of burglary in Nevada is any person who by day or night enters any room or building with the intent to commit any felony is guilty of burglary. So the key is just entry into the room or the building with the intent to commit a felony inside that room or building. So entry and intent. So I'll talk about each one of those. So in this case, the defendant is charged with 3 counts of burglary. So that's why there was so much testimony about where these documents were filed. So every time the defendant
Yes, we watched every minute and didn't skip anything.
entered either the room in this building to file his forged documents or entered the family court building to file his documents, he was committing burglary. Do you know that he entered those places? Well, December 4th of 2017, Brett Zagowski saw the defendant on surveillance video inside of this building, the Regional Justice Center, located at 200 Lewis Avenue. That's the day that this document was filed. And you heard Christina O'Connor's testimony that this document, the December 4th, 2017 pleading, was filed at the customer service desk at the district court clerk's office, which is in this building. And Detective Stanton testified specifically that that's room 3317 on this building, in this building. So there's plenty of evidence here that beyond a reasonable doubt, the defendant came into this building, the Regional Justice Center, and entered room 3317 in order to file this document which contained a forged letter. March 13th, similarly, on that date, this document was filed in family court. This document contained the forged letter and the financial disclosure form. Christina O'Connor testified that this document was filed at the Family Court Center, which is located at 601 North Pecos Road, and it was filed on March 13th of 2018.
I didn't. I never saw this before.
Timothy Spees saw the defendant in the reading room at the family court on that date, the same room where people go to file their family court documents. Now, March 21st of 2018 is the last burglary count. That's the date this document was filed in family court. And Christina O'Connor testified that this motion was filed on March 21st, 2018, in person at the Customer Service Center at the Family Courts and Service Center at 601 North Pecos Road. Now, the second part of burglary is intent. Because some of you may be thinking, well, how do I know what his intent was right at the moment that he entered the room or entered the building. You know, I'm not a mind reader, but you don't actually have to be a mind reader. As one of your jury instructions tells you, the intent with which someone does something can be inferred from the defendant's conduct and from the other circumstances surrounding the case. In other words, what a person does can tell you something about what that person intended to do. Okay, so on December 4th of 2017, when the defendant entered the district court clerk's office in the Regional Justice Center, this building, what did he do? Well, he filed a forged document. He offered a false filing to the court. Okay, that's why I went through those offenses before I got to the burglary. So we can tell what his intent was because that's what he did upon entering those buildings. It's not like he worked there and had some other reason to be there. That's the purpose of the district court or clerk's office, is to file your documents there. Okay, so you don't need to be a mind reader. What did he do in room 3317? He filed these forged documents. So when he entered, he had the intent to commit the crimes of offering false instrument for filing a record, as well as to commit forgery. And in order to commit this crime, to have the required intent, you don't have to be thinking to yourself, oh, I'm going to commit forgery right now, or oh, I'm going to commit offering false instrument. No, you don't have to necessarily know exactly what crime you're violating. You just have to have the intent to commit the act. When the defendant, Mr. McDonald, entered those rooms, he knew he was filing a document that had been altered, a document that was forged. He knew what he was doing. He may not have known the name of the crimes, but he was acting knowingly. Now, perjury. There are 2 different counts of perjury that are charged in this case. So that's counts 6 and 8 of the indictment in this case. So I'm going to talk about count 6 first. Now, to commit this crime, in a declaration made under penalty of perjury, making a willful and false statement in a matter material to the issue or point in question. I know it says 2 elements, but sorry, that's a typo. There are actually 3. So first, in a declaration made under penalty of perjury, you make a willful and false statement in a matter that's material to the issue or point in question. So I'll go through all 3 elements. Now, the first one is the declaration. And so what I'm talking about here is the financial disclosure form. And this may be a little different from what you think of typically when you think of perjury, but it's not just testifying in open court. It can also be when you sign a document. And this is a snippet from Exhibit 5, which contains the financial disclosure form that the defendant signed. And on this form it states, I swear or affirm under penalty of perjury that I have read and followed all instructions in completing this financial disclosure form. I understand that by my signature, I guarantee the truthfulness of the information on this form. I also understand that if I knowingly make false statements, I may be subject to punishment, including contempt of court. You have signature, and what's the date? March 13th of 2018. And you heard some evidence that the defendant, Mr. McDonald, may have filled out a financial disclosure form back in September, back before he was employed by Prosecution. But what is the date on this form? March 13th of 2018. On this date, by signing this, he was telling the court what's contained in this document is true. I'm swearing that under the penalty of perjury. So we have the first element met. That's the declaration. And we know that it was false because this is from another exhibit, the Prosecution's employment records, which show the defendant was hired on October 23rd of 2017. He had a salary of $47,500, and he was a full-time employee. He was a systems administrator. But this is what he put on his financial disclosure form. Gross monthly income, 0. My gross year-to-date pay is, honestly, not really sure what that says.
We know what it says. It's a question mark. They're all question marks, he said. They're not zeros.
Up in the right corner. It kind of looks like a 0. I think when he testified, he said he added a question mark to it. But it doesn't look anything like what his actual salary was. It's a couple of zeros right there under annual salary. But what was his actual salary? $47,500. We have a willful and false statement. I don't know how it could be any clearer. He filled out a form stating that his annual income was zero, when in reality, at the same time, he had a salaried position as a systems administrator in which he's receiving $47,500 a year. There's his pay stub. So as I pointed out before, he signed that declaration under penalty of perjury on March 13th of 2018. What's the pay period on this pay stub? March 6th through March 27th of 2018. Looks like he's employed at me. That's his name in the upper right corner. You heard Lisa Smith's testimony. She's the VP of HR at Progistics. She said she saw Michael McDonald every workday. He was their IT guru. And how much is he getting paid? About $1,800 every pay period. It's a heck of a lot more than zero. Now, is it material to the proceeding that he was there for? Well, it was a child custody hearing. It was an evidentiary hearing related to that. And you heard Marshall Willick, and who's an expert in family law and has been practicing family law.
That's not evidence. I think material was testified to.
Now, what I mean by material is essentially that it was important, that it was related to something being decided at the hearing. If Michael McDonald had just, say, accidentally said he was born on October 21st of 1983 instead of October 22nd, we wouldn't be here. Not really material to a family court case, you know. But in this case, he lied about his financial status. And you heard Marshall Willick testify. He's been practicing family law for approximately 30 years. And he discussed the financial disclosure forms in particular. A person's financial status, I believe he used the word critical. He said that it was critical to making determinations regarding child custody, child support, spousal support, all kinds of family court issues. This wasn't some minor matter that he made misrepresentations about. This was something that was very critical to the proceedings, that Mr. McDonald, the defendant, was purposely and deliberately deceptive about. So that's count 6. And now we'll move on to count 8. So this is the more traditional version of perjury. So to commit this kind of perjury, it occurs when a person, having taken an oath or made an affirmation in a judicial proceeding where it's required, swears and affirms willfully and falsely in a matter material to the issue or point in question. So kind of similar to the witnesses in this case, they were all sworn in to tell the truth. And you saw Mr. McDonald swear under oath on the video. So again, these are the 3 elements: swearing under oath, giving willfully and falsely testifying in a matter that's material to the issue. So was Mr. McDonald under oath? Yes. You saw him get sworn in on the video on March 16th of 2018 in family court. There he is raising his hand. Was his testimony willfully false? Well, he testified that he was unemployed, other than having some odd jobs. And this wasn't some minor mistake. He didn't say that he only made $1,807 on one paycheck when it was really $1,808. What he actually said was that he was not employed, that all he had were odd jobs. And in reality, he had a full-time position.
No, Debbie, he can't handle my cats.
As a systems administrator at Progistics Distribution. He was working there since October 23rd of 2017 and was still working there on the date March 16th of 2018, which is when he testified.
Neither can I, really.
He testified that his average monthly income was $800. And at various points, it seemed like he was saying it was $800. At some points, he said it was zero. Sometimes he seemed to be hedging it, but he clearly didn't say it was anywhere near what it actually was. In reality, his annual salary was $47,500. And you've seen his pay stubs. Each one was more than $1,800, and they were 2-week pay periods. I don't know how it could be any clearer that the testimony the defendant provided on March 16th of 2018 was willfully false. And I've already discussed the fact that it was material to the issues. Similarly to the information that he put on his financial disclosure form, his testimony, his live in-person testimony, was also material to the point in question. And largely what he was testifying about, or at least what he was cross-examined about on that you saw in the video, was the information that he wrote down on his financial disclosure form. And he acknowledged during his testimony that that was his form, that that was the exhibit that he filed. Now, so what do we have here? The defendant obtained a letter from his therapist, Nancy Hunterton, about August 31st of 2017. He got that letter from Ms. Hunterton. He added a sentence to that letter to make it appear as though Nancy Hunterton had stated that Michael McDonald was not a danger to his children or to himself. But she did not write that. That's what makes that letter false. The defendant passed that letter off as genuine, as the actual letter that she wrote, when it was not. He did that on 3 occasions. He perjured himself, both by...
We don't ask for much. We just ask that you do not speak clearly and you do not give us facts. Come on.
Filling out his financial disclosure form, the declaration under penalty of perjury, and by giving false testimony on March 16th of 2018 when he testified in family court. I submit to you that the state has proven beyond a reasonable doubt that the defendant is guilty of all of the counts listed in the indictment in this case. 3 counts of offering false instrument for filing a record, 3 counts of forgery, 3 counts of burglary, and 2 counts of perjury. I ask that you find the defendant, Michael McDonald, guilty of all counts. Thank you.
They missed a huge win because they didn't show where he was in court. And he repeatedly says over when the judge is saying, that line looks a little wonky, it's different. And he's like, nope, that's legit.
Thank you, Your Honor. Counsel, your notes? Sure. Ladies and gentlemen of the jury, not guilty. If you're sitting there confused about this case, you're not alone, and you're not wrong to be confused. There are so many things wrong with this presentation that we're going to have to take a long time and go through it part by part. I'm going to have to give you guys a lot of information, so I want to dissect this case very carefully, and you want to look at it from the angle that matters, and then come back. First off, mistakes.
I'm already over him. I'm not confused. I do not want you to go through it part by part.
Mistakes are material, or they are immaterial. My colleague, despite her diligence and very thoroughness, has actually made a mistake in the indictment. She's actually got Mr. McDonald's birthday wrong, off by 10 years. Now, is it a mistake? Yeah, it's a mistake. Is it a material mistake? Well, I don't think she really meant anything by it, but when you go back there, you'll see that his birthday is wrong. So those are mistakes. Specifically, when you get back there, I think it's count 3, but you'll see his birthday is wrong. It's off by 10 years. So that's a mistake. And the question is that a material mistake? And if it's a material mistake, was something meant by it? So let's go through and let's talk about this case, because this case, candidly, is probably one of the most disturbing and fundamentally important cases that has been presented in a long time here. Because this is a case attacking a man who decided he wished to participate in the political process. Detective Stanton...
Objection, arguing facts not in evidence.
Actually, it's Detective Stanton actually said that.
back yet?
Yeah, that's
No, that's not how it works.
Hi, ladies and gentlemen, the jury.
Wait a second, does it come back yet?
yeah, that's
Okay, go ahead.
All right, ladies and gentlemen, the jury. Let's think about this. Let's see what we've talked about, what we've seen, and let's talk about what we haven't seen. Where was Judge Marquis? Why hasn't she taken the stand? Why hasn't anybody from one of those court proceedings testified? Where were they? Marshal Willick was called by the state. He was an expert. So I encouraged him to listen to his insight about the case. Mr. Willick, a court has extraordinary powers to discipline litigants, does it not? Yes. You can ask for new paperwork. You can direct it to be done, correct? You can hold someone in contempt. Yes. You can hold someone in civil contempt. Yes. You can hold someone in criminal contempt. Yes. You can refer the kidnapping case to prosecution. That's what a judge can do. But that's not what happened here. The police department, on its own initiative, decided to investigate somebody in family court. A 25-year detective, who by his own admission doesn't know a thing about family court, has no reference in family court, has no frame of reference about what's important or how family court works, decides that he is going to investigate Mr. McDonald for problems with this case. Judge Marquis doesn't request it, nobody asks him to, and yet it happens. Why? Does a detective know what's material? Does a detective know how this paperwork drill works? Every one of you, we have a lot of high-powered people. We have an engineer, we have someone in security, we have someone from law firm, we have several people from very high-powered industries. Knows that in every industry, there's paperwork that you have to pay attention to. There's stuff that's really important. And there's stuff that, doesn't matter as much. For example, my colleague's mistake with Mr. McDonald's birthday. It doesn't really matter much. It's not a material mistake. I know that. We do criminal law every day. But in every line of work, you have to know what you know, and unlike our good detective, you have to know what you don't know. And the detective doesn't know what he doesn't know. So he assembles this case. Why? Because Mr. McDonald's come to his attention. And therein lies the heart of this case. Why is Mr. McDonald on the good detective's radar screen? Why? We asked him over and over again. I've got an anonymous tip. Oh, an anonymous tip, detective. What was it? It was off the Nevada court website. Well, isn't that a little confusing, detective? You mean somebody can anonymously type something up and you're going to go investigate based on that alone? Well, yeah. I'm a little confused. Isn't that on Facebook? Well, yeah. Well, the fact of the matter is, as Mr. Willick said it, you can't anonymously post on Facebook. Someone had to post that. So the detective is doing somebody's bidding, or at least following up on a publicly posted Facebook post. Then the state calls Mr. Willick. He's their expert. He's going to come in and show you people how family court works, give you some perspective on things. But it turns out it's Mr. Willick's girlfriend's employee that actually posted all this material. Mr. Willick's actually complicit in everything that happens in this courtroom, and it's done for retribution. That's why this case is filed, and that's why my colleague, despite her very gallant efforts, can't coherently explain to you any theory of criminal liability that makes any sense. Now, if you had a good case, you need one charge. You don't need 11, and you don't need 3 or 4 different theories of liability, and you don't need to come up here with a PowerPoint and explain them to everybody, because the truth takes few words. So let's go back and deconstruct this nonsensical argument that the state has presented. Where is Miss Hunterton's affidavit, ma'am? No, I think it was 6. Counsel, do you remember?
I think it was 9.
9? It was 9. Thank you.
Actually, I think this was 7.
7 or
8.
8? Okay, we'll split the difference. And Madam Clerk. All right. Now, let's talk about material versus non-material mistakes. My colleagues got Mr. McDonald's birthday wrong. No big deal. Not a material mistake. I don't think anybody in their right mind would think so. All right, maybe if it was underage drinking case, that might be a material mistake there. But in this case, it's not a mistake. So, Mr. McDonald, in context, is litigating a case. He's got no lawyer. God rest his soul, the lawyer killed himself. He's got no money. So Mr. McDonald has to do this case by himself. Now, imagine getting handed a stack of rules, some paperwork, and everything that's near and dear to you is on the line, and you have to do the paperwork right.
I can't remember. Jägermeister keeps coming to my head. I have it, so I have a tip of my tongue, but Jägermeister's there. Nope, I'm not going to make it. I don't
And they say,
remember.
nope, can't help you. There's the self-help center. That's it. And these are the people who want to convict that man of a crime. So let's look at this. He has a hearing coming up. He has to go see a therapist. Okay. Ms. Hunterton goes and says, he's been coming to see me. I wrote a brief letter. He'd see me for individual therapy. It addresses related to divorce, his well-being, and develop his insight related to separation from his wife. Given Mr. McDonald, I asked him to write a letter saying that I would not pose any danger to children. I would be willing to do that and have given the opportunity. Now, you heard her. She said he asked for the letter. He came and saw me. I agreed to do it. That was a testimony. I agreed to do it. But I got busy, and it was the end of the day, and we didn't get around to it. It's a court hearing. He's got to have his letter. So he adds the letter in, the sentence in for himself. Was that material? No, it's true. She adopts it. There it is. There's her adoption of the letter. She testified under oath now twice that, yeah, no, I don't think he was a threat to the kids. So how can you have a forgery when you're telling the court something that is true? Remember, he doesn't do this every day. He's down there trying to get some access to his children back. So there's no material fraud. There's no element of intent to defraud. If she said no, and he writes yes, the material coin flips the other way. That's clearly a material mistake. This isn't a material mistake. He puts letter in. Then the state wants you to charge him for a felony count every single time he puts the same document on file. No, absolutely not. Doesn't make any sense. Now, then we come to the other key issues here.
Hello, Canada. I love when Canada comes.
We gotta come
I'll show
back
you
to the
why.
concept
Hold
that my
on.
client, or my colleague, kind of hopped over and she doesn't want you to think about. Materially. You see Mr. McDonald standing up there, you're raising his right hand, swearing to tell the truth, the whole truth. Was his financial affidavit even material to that hearing? Where was the people that were at that hearing? Where was that lawyer? You saw the lawyer, I don't even know his name, he's busting Mr. McDonald's chops pretty hard. How come he's not up here talking about the hearing? He didn't come in here, and there's been not a scintilla of evidence. Not a scintilla of evidence that anything in this affidavit was material to the issue at hand. And since we've got scientific and technical people, let's go through and let's listen to what we don't have, or let's hear what we don't hear. And I said that intentionally to get your attention. Where is the person on the witness stand saying McDonald's a deadbeat and not paying for his kids? Nobody. Why do you think this Ryan's
Canada.
affidavit is material in this particular area? No one says he's behind. No one says he's not paying. Nobody. It's not here. It's not in the case.
He actually did not say that on purpose. He's just stupid.
Where's the judge? Where's the judge who said, yeah, we had this hearing, the whole issue was this, and he didn't do it? She's not here either. Why? Because there is no material issue at hand. He is out of favor with the powers that be. And they've combed through his material stuff and trying to find any big human mistakes in this paperwork, and therefore to punish him. This is very different than criminal law that you and I have been taught to do it. Go out and find the bad guys. That's not this case. This case is, let's find someone who's pissed us off and let's see what kind of crapola charges we can hang on him. Because that is what is in fact happening here.
It won't let me.
There's nothing in here that's going to make you proud of your legal system. There's nothing here that's going to make you proud of your government. Mr. Willett got out on the witness stand. He's in charge of Nevada court watchers. His fiancée posted this website, her employee posted that on this website. And they don't want you to know that. They didn't tell you that. That came out on cross-examination, and only reluctantly. And a 40-year lawyer who certainly knows how to parse words, did you see his weaselly demeanor on the stand? Let me think about it. He's not an honest broker. This is a hit job, through and through. Then we talked about the remedies. What kind of remedies does a district court judge have to discipline litigants in front of him? All sorts of remedies. We spent 2 sessions. I came back and asked him second time what the remedies are. And I asked him, I said, right here, holding the other way, and I say, Mr. Willett, in your 40 years of experience, can you remember another case where the police independently came down to family court and start crawling through somebody's divorce proceedings? Well, there was a case where they kidnapped the kids. Yeah, they kidnapped the kids and took them overseas. Okay, kidnapping, yeah, that's a criminal charge. I think we can all agree on that one. Is that what the state wants? Kidnapping? There's no crime here, folks. Mr. McDonald, if he's committed any crimes, he's committed one crime. That's pissing off people. He criticized the judge. Where's the judge here? He criticized the legal system. Who's here saying that there's any problems? Where's the materiality in these hearings? It's not here. And then finally, this burglary charge. This is troubling as well. Burglary is the entry with intent to commit a crime. How do we know? How do we know? There are people who mean well. There are bright people who mean well, but don't know how to do paperwork or don't know what's exactly looking for. Every line of work has its favor, it has its style and its paperwork, order forms for materials, for restaurant supplies. You got to get things right. You got to learn your job. But every one of our jobs has its different things. They're called trade practices, things that are done this way. Mr. McDonald appears to be held accountable for not knowing lawyers' trade practices. And here's the other practical problem, and my colleague seems to want you not to pay attention to this. This proceeding's been going on for 5 years. This is 5 years of who shot Johnny. Oh, well, the people go back and forth with each other. You heard the lady. She spoke highly of Mr. McDonald. Great, good IT tech. I liked him, saw him every day. We were paying him. What day did he start? October 17th. What day was this affidavit from? At least the first one? September, when he was unemployed. Now, I asked the detective, and I apologize, it was a little out of hand. I asked the detective, you've been through a divorce, yeah? Do you know how often you have to update your forms? No. I've just got through with a divorce. I don't know how often I'm supposed to update my forms, to tell you the truth. All right, I don't know. And I just did it, and I'm a lawyer. He just
Throw him
did
in
it.
jail.
He's a cop. He doesn't know. So how's Mr. McDonald supposed to know? Now, is that really a crime? Is that really what you want your government to throw people in trouble for? You, not the judge, not I, not my colleagues here, are in fact the final arbiters of the facts of this case. And in this case, there are huge missing gaps. There's materialities. There's no intent to defraud. There are no fraudulent statements. And there's no eyewitnesses. There is no way to prove that what his intent was. And there is no way to determine what was material in that hearing. She has stood up and just wants you to assume and presume. It's a very important case, very confusing case, and if you're confused, you're right to be. The state has not done a good job presenting this case. And despite her outstanding organizational skills, she can't organize stuff that doesn't exist. Where is the one eyewitness anywhere in this case? Where was the lawyer who cross-examined him? Where was the judge who presided? How about the court clerk who was there? Where was the person that said, yeah, actually, this was a document I saw him sign? None of that's there. Very important case, folks. Very tedious. I sincerely appreciate your time and effort for jury service. When you get back there, I think it's this time it's 29 is our current, is the common sense instruction. The reason we, as our society, not me, but we as our society have chosen to install juries is because together, each of you have 20, sometimes 30, 40 years living on this planet. You know how the world really works. And the 12 of you together bring 240, 260, maybe 300, 400 years of life experience. All the walks of life, engineering, communication, security, medicine. We have all sorts of interesting life experiences together. And together you will have more wisdom than collectively than any one individual does. And when you go back there and use your common sense, you should be troubled by this case. You should be deeply troubled by this case. And you should be deeply troubled by what you have not heard. You have not heard any direct evidence. You've not heard any issues of materiality. And we all know in the real world, no matter how hard you try, when we all have to get stuff done on deadlines, people make mistakes. And even as someone who's diligent, and I'm sincerely my compliment, someone who's diligent as my colleague is, she's made a material mistake in this indictment. Now, mistakes get made. The question for you to discern is whether these piddling mistakes are in fact material to the charge. And that's where the heart of this case lies. Where are these material mistakes? And do we really want to put a guy who's representing himself in a conviction, or give him a conviction, in family court, after he paid for a lawyer and the guy killed himself? Ladies and gentlemen, truth takes 3 words, and I'll sit down. This is a not guilty case across the board. I'm going to sit here and go through this with you and very briefly explain this to you. All right, burglary. Burglary under Nevada law is very simple. It's a chop shop. Entry with intent. Guilty of burglary. Now, my colleague has elicited and has advanced 3 theories. On this one, I guess, presumably the 4th day of March of 18. Not guilty. What was in his mind when he went there? Well, you heard that he comes down there on the courthouse as a court watcher. That's court watchers. You don't even know why he was in the court that particular day. What was in his head when he filed it? Was he scheming, I'm going to go in there and file this false document? Or is he like, hey, I got to go to court, I'm going to sit and watch somebody else? There's no evidence there. You cannot convict Mr. McDonald of burglary beyond reasonable doubt. Forgery, not guilty. Once again, the letter is submitted. True. Mr. McDonald changed it. True. He confessed that he changed it. Showed the detective he changed it. The question is, was it from yes to no? Was it material? No. He asked the therapist, will you write this? Yeah, I will. Do you agree with it? Yes, I will. Can you do it? Yeah, come back next week. Well, my hearing's next week. So he changes it. Is that a material change? No, he said exactly in that letter, exactly what she intended to say. So that is not guilty. filing false instrument or record. Okay, what's false? That he wasn't working? That he was? Once again, what is the false in here? He had a job for a while, and then he didn't have a job. Should he have updated the records? Did he not update the records? Were the records carried over from a hearing when he didn't have a job to when he now has a job? We don't know any of this. The judge isn't here. No one from the courtroom ever showed up in this case. Nobody asked any of the material facts here. So the answer is not guilty. Burglary. Here we are again. Pictures of him standing in the courthouse. Well, we know he's in the courthouse. So, what was in his head? Now, burglary usually means if you run into a building with a gun, okay, we know that you went in there to commit a crime. That's the burglary. Or if you went in there with burglary tools in your hand, you kicked the door in. That's an intention to go in and commit a crime inside. All we have here is a picture of a man in a courthouse. That's not guilty of burglary. Forgery. Once again, not guilty. Same document, yet again, run up, and it gets put back in the pleadings, and it's not guilty. It's not forgery. There's no material effort in it. Perjury. Not guilty. Perjury has to be a material misrepresentation of fact. My client, my colleague here, hasn't committed perjury by putting a wrong birthday on the instrument. That's not a material misrepresentation. It's a subsidiary issue. Perjury is on substantive. I solemnly swear the truth, whole truth, and nothing but the truth. I was never in the judge's courtroom today. I did not sit in Department 28 all day. Now I'm committing perjury. Why? Because that's a material fact. I was here all day. Everyone knows I was here. Material facts are required for perjury. Once again, what was the purpose of the hearing? What was the purpose of these documents? If the judge says, I want to find out about your work schedule, and he turns in the paperwork for a couple months ago from when he wasn't working, is that really a material fact? We don't know, because it wasn't in the evidence. So the fact of the matter is, that's got to be a not guilty. False document or record, not guilty. Perjury, not guilty. Burglary, once again, I'm in the courthouse, okay, not guilty. Forgery, not guilty. False, not guilty. Read the statute. The false or partial statement or filing a false document has to be material intent to defraud. And I've got my notes here. Why do we have 11 charges and no evidence? Why do we have a case started by a detective and not a judge? Why do we have a case that's supposedly taken off an anonymous website, but actually wasn't off an anonymous website? It was actually Mr. Willard's girlfriend's employee. Why do we have these things? This isn't a criminal case, folks. This is political retribution. This is impure motives, and a case that should be a complete across-the-board finding of not guilty on every single charge. This is very important. Please take your time and go through this with care and deliberation. Thank you.
McDonald. Thank you, Your Honor.
I'll get away too.
All right, I got a plan. I got a nice plan. If, depending on how this turns out for Michael, if he doesn't get hit with perjury, I'm going to go to my doctor tomorrow and, just for like a checkup or something, or just go in to ask a question and ask for a summary or a doctor's note because I missed work. And then at the very end, I'm just going to type in there, but she can't work anymore. All right, guys, fingers crossed.
We're back on the...
Record, thank you, Council and Mr. McDonald, for giving me a moment to review some documents. Thank you, Mr. McDonald, for giving me a moment to review some documents. Come on up back to the witness stand. I'm going to ask you to put your phone away. Council, continue.
Listen, I will have unbelievable strength for beer. You can arm wrestle me all you want, but I'm drinking that beer. I'm probably going to drink the beer while you're arm wrestling me.
Where are you currently living?
Close to UNLV.
Can you tell me your address?
I prefer not to, as I don't want to be stalked or...
You don't want to be stopped?
Judge, I've been being stalked recently as per my evidence, and I would not like to disclose my address.
Okay.
You're not currently living at 5812 Harmony Avenue?
Correct.
And that's the address you have listed on your most recent financial disclosure, correct?
I sometimes use it as a mailing address.
And whose address is that?
Stepdad.
Are you currently working?
I do odd jobs currently.
What type of odd jobs do you do?
And some computer stuff, some real estate stuff.
$20 is $20.
And how much do you get paid for those odd jobs?
I try to make it, I do as much as I can to make like $800 to pay my bills, like at least $800 a month.
And you realize that you've listed on your financial disclosure that you make $0, correct?
I believe that's true.
Have you ever copied your financial disclosure that you filed?
I don't think I do. I think it's in the exhibit list. It might be over there. So I'm also a student right now and doing my best to get work. I tried to get rehired at my old job and was unable to.
You paying for school?
I'm going for financial aid and scholarships.
You're submitting paperwork for that, or you already have that?
I submitted for financial aid, yes.
You're not currently receiving it?
I got approved. I didn't get approved for last semester, but I should be getting approved for this upcoming semester.
So you went to school last semester? How did you pay for school last semester?
Through financial aid. I think I still owe them some money on that, so we're still waiting on the funds for that.
When did you start and you're attending school at UNLV, is that correct? When did you start attending school there?
It's the winter semester of 2017.
Isn't that semester still going?
No, it's spring semester.
And on your financial disclosure, despite listing that you make $0, you claim $800 in business expenses, correct?
Yeah, I filled it out inappropriately. 800 is around what I'm currently going for each month. I'm doing my best to earn.
Okay, because you also, so you have on your business expenses, you have a car and truck being used for business that you spend $100 a month on.
That's a gas charge, I think, if I recall.
For insurance, $100. For mortgage or rent, $550.
Yeah.
Are you renting out an office space?
It's zoned commercial and residential.
So you're living there? And utilities at $50, correct?
That's part of the 550.
Is there an argument to be had?
So you have, so you list here that your
Objection overruled.
average gross income from self-employment or business is $800. Correct?
fluctuates,
And
yes.
then $750 in business expenses. Okay. And then you also filled out the personal expense schedule. And you have a total monthly expenses of $1,050.
Yeah, so I also have a rental contract where I can have reduced rent for doing different jobs around the limits of my friend's house, so.
Okay, so is that a business address or is that a lease? So you're paying $550 for rent on a business and $500 for
No,
rent
it's
on an
correct.
apartment?
It's a commercial and residential place. It's a big place that I have. I also have beds for my kids. I have everything in place for them as well. Take them over there.
Okay, but if you're, as you say here, if you're making $0 a month,
I didn't state that, but
I'm gonna have you, you don't have a copy of your financial disclosure? I'll have you, look at this. Can you just review that real quick and then I'll answer some questions?
Thank you, guacamole. Thank you so much.
okay.
Does that appear to be your financial disclosure?
Appears to be.
Is that your signature on the back page?
So,
Is that your handwriting with your name at the top of the front page?
so.
Okay, and if you look on the second page, what does it state for your annual income? Up towards the top.
Year-to-date income, is that what it is?
Yep.
Yeah, I don't think I filled that out. What was it?
Does it have zeros written?
Oh, I think it's question mark, because I don't know exactly how much it was.
So those aren't
'Cause
zeros.
I was unemployed for
that category?
oh, this year, 2018.
You gifted my son a membership. He doesn't even spend that $1 a month it takes to be a member of my channel. Anthony. Nicola Love, you got a membership. Thank you so much.
Yeah. Yeah, I wasn't sure what to put there.
The record speaks for itself, counsel. I can see the financial disclosure form that he filed with the court that says gross monthly income 0.
Okay, so that I might have divided by 12.
0, 0, 0,
Yeah.
0 divided by 12,
I
0.
might have put that.
Okay, next question.
I apologize, ladies and gentlemen. I'll try and be brief. I know it's been a long couple of days.
Oh, you're Maria. I knew
Unfortunately,
you
now
were
I'm tasked
Maria.
with correcting some of what you just heard from defense counsel. The defense would have you believe that there's some sort of far-reaching, highly sophisticated, concerted conspiracy that involves the Metropolitan Police Department, specifically some highly trained detectives. Apparently, Ms. Mishler and I are in on it. Judges, multiple, from both district court and family court, as well as marshals from both of those courts, as well as apparently a family court expert that testified today. He's in on it too. All have come together and conspired to get the defendant. Ladies and gentlemen, this is not a Hollywood spy thriller. This isn't a John Grisham novel. And I assure you that nobody on that list of alleged conspirators has the time to waste on such nonsense. The truth is infinitely more simple and much more boring, in fact. The truth is that the defendant, Michael McDonald, under oath, after swearing to tell the truth under penalty of perjury, lied, even misrepresentations. He changed a document, altered it, constituting forgery, and then entered the courthouse on multiple occasions and filed it as if it were true. And then he got caught. That's the whole story. So he got caught. There's been a lot of talk about how he got caught. Specifically about this Facebook post. And so I want to talk about that a little bit. First, I just want to clear up a little bit of language. And I'm going to talk about the importance of language in a little bit. But there was much reference by defense about an anonymous tip. And the detective, as you'll recall, tried to correct that. It was not anonymous. It was not fed to the defendant or to the detective. He monitors these websites, and somebody posted it. Not anonymously, as defense said. It's Facebook. It includes a name. And as part of his job, the detective then looked into this allegation. The big question along the way was who posted it, and what were their intentions? What were they trying to accomplish? What if it was the ex-wife, right? The scorned ex-wife. What if it was this David Schoen or Shore character that happens to be the employee of the spouse or the fiance of a family court expert? What if it happens to be the neighbor of the defendant who's mad that he doesn't pull his weeds? Or an ex-girlfriend from high school that's still upset about what happened 20 years ago? What does it matter, ladies and gentlemen? What's the relevance of where the allegation came from? What's important is that the detective, doing his job, became aware of an allegation. He investigated, corroborated, he substantiated, and now the state has proved beyond a reasonable doubt that those allegations were true, and that the defendant, in fact, did what was alleged, regardless of who made that allegation. I can understand the defendant being upset that somebody snitched on him, that's understandable. But why does it matter where it came from? It doesn't. Lest we be confused. In regards to the allegation, first of the residency violation, and then of the forgery, I want to correct a little bit of the timeline. Because there were some questions from the defense about why didn't you just drop it after you found out he actually lived where he said he did? And the detective, you'll recall, tried to correct that. He said, well, by the time I found out that that wasn't a violation, I had already also found out that there was an allegation of forgery, and I was investigating that. So yes, he dropped the residency violation investigation when he found out. But as detectives do, as their job entails, he continued to investigate other things. I mentioned just a moment ago that language is important. Language matters, certainly in trials, and as we've become well aware, certainly in court documents. But specifically, I want to mention a couple of these things. Like I said, an anonymous tip versus a public posting. One sounds sexier, right? And it kind of makes us think more. Another one that came up today was court watchers and Marshall Willick. Multiple times, the defense asked him about being an administrator. In fact, just now in his closing, he said he's in charge of court watchers. You recall, Marshall Willick tried to correct him multiple times and said, no, I have no ownership. No, I'm not in charge of it. I'm not an administrator. I contribute sometimes by posting and answering questions, as I do on many other sites. He does it, he said, as a public service to people that are asking questions about cases that they have, specifically in family law. The importance of language. Another one, and I apologize, we had to sit through that again. You'll have that back in the deliberation room. You can watch all the videos.
No, he doesn't.
The defense counsel said the attorney there for the ex-wife went to town on the defendant. And another time during question, he said he'd be badgering. Actually, watching it over again, I think he was quite polite. Certainly didn't require him to apologize later. He's not a danger to his children. versus, well, I believe him seeing his children would be positive under regulated and recommended guidelines. You see the difference in that language? In regards to that, you heard defense just say, after admitting that his client, the defendant, added the language, he said, this is a quote, he added exactly what she intended to say. That's what defense counsel just said. He added exactly what she intended to say. Do you remember Ms. Hunterton on the stand when defense counsel asked her multiple times, well, isn't this substantively true? Substantively versus exactly? And even when he asked substantively, isn't this what you think? Do you recall her hesitating? And eventually she said, well, no, I would have written a very lengthy paragraph about what that meant and what it entailed and what would be required. Language matters, ladies and gentlemen. There was a lot just spoken about in regards to, well, he didn't know. He didn't have an attorney. Actually, the evidence has showed that he had multiple attorneys. Evidence also showed that 60 to 70% of family court litigants don't have an attorney. It's quite regular.
Maybe.
What he did know is he apparently knew that he had to file an exhibit list, which is actually a new revision and a new requirement for the expert that testified. He knew that he had to include a financial disclosure form within those. It was very litigious. He's not a half-wit, ladies and gentlemen. He's a professional IT, salaried employee. Instruction 28 talks about...
Yeah, see, if you're a professional IT, you're not a halfwit. Do you see, guys? A lawyer said that, so it must be true.
Ignorance of the law not being an excuse.
Yes, that's fuzzy.
Ignorance of the law is no excuse. Everyone is conclusively presumed to know the law, and one accused of a crime is precluded from using it as a defense. Is ignorance of the law. There was also testimony from Marshall Willick about the fact that there's a self-help desk. He actually, like I said earlier, answers questions for free as a public service on multiple websites. As an IT guru, you think you know how to use Google and research the laws, find out if what he's doing is not right. And yet, despite all of that, according to law, ignorance that what you're doing is illegal is not a defense. It's not an excuse. Defense counsel also pointed out the next instruction, which is the common sense instruction. That you can use your common sense as smart individuals, although you're sitting in that box, doesn't mean you can't think outside of it. You can think about what a reasonable person would do. You can reasonably infer things based upon the evidence that you've heard, that you'll see, that you have seen, that you can take back there with you and look over again. There was also a lot of questions
I'm going to ban you.
from the defense about how unique this case is, and he just leaned on that a lot. This is a conspiracy, and you know that because this is a very unusual case. The hundreds of thousands of documents posted every year, how many from family court end up here? Let me remind you that there are many different crimes. There's murder and there's perjury, right? You could argue one is more serious than the other, but they're both crimes. You have the law that backs up the fact that perjury and forgery and burglary, those are crimes in Nevada. You could argue they're not as serious as murder. I might agree with you. But that's not why we're here. We're here because he committed perjury and forgery and burglary and filing a false document. In fact, the defense asked the detective, you'll recall, after establishing he wasn't a family court expert, after finding out that these things had been done, he asked, did you ask anyone if this was a big deal? Well, the detective laughed a little bit and said no. And we established that no, he's not an attorney, but he certainly knows that...
It could be worse. You could be Sarah.
Forgery and perjury and burglary and doing the things that the defendant did is a crime. And so as a detective, he investigated that and submitted it. A crime is a crime. And interestingly enough, and he just talked about it again, the defense counsel asked Marshal Willick, in all of your 40 years and thousands of cases, have you ever seen anything like this? And Mr. Willick said, yeah, I've seen it a couple times. Yes, something from family court ends up here. And confident in that he knew the answer, he said, well, give us the facts of some of those. And you'll recall that Marshal Willick actually recited the name and specific facts of a case. And as you just heard, yes, it involved eventually charges of kidnapping of a father who had lost custody and took his children without permission. But then when asked specifically how that case started, you'll recall, Mr. Willick said, well, it started with a divorce case. And that the father, the defendant, lied about where he lived. That's how it started. Literally almost exactly how this case has started. So yes, it's not out of the realm of possibilities that we end up here in criminal court for criminal allegations and the defendant committing actual criminal offenses. I understand that, and it's been said a lot as well, that family court cases have high emotions. There's a lot riding. There's a lot of bad blood and people yelling. There's been a lot said that he wanted to see his kids. And that's evident from some of the posts, the litigation that went on. You can read the titles and what he was trying to accomplish. What I will point out at the bottom here of that same 29 says a verdict may never be influenced by sympathy. Never be influenced by sympathy. Not that you shouldn't. You cannot be influenced by sympathy. The fact that he may have wanted to see his kids, that doesn't mean he can do criminal things in order to see them. That still constitutes a crime, even if his intentions are to see his kids. You cannot be influenced by sympathy, ladies and gentlemen.
Not a problem.
One of the major reasons you were chosen as jurors, you'll recall you were asked many, many questions, and among those was that you are willing to follow the law as it's presented to you and as the judge has given it to you, even if you don't agree with it. This, and you'll each have a copy of it, this is your rule book. These are the laws. And if you find that the defendant broke these, regardless of his intentions, to see his kid maybe, that means he's guilty of what he's charged with. The defense brought up that you didn't hear from Judge Markey. What exactly would you have asked Judge Markey that we could actually get into? What could she have added to the case that we didn't get into? Same as for the wife's attorney, that we didn't hear from him. What would he have told you that would prove further that you can't see in the video, that he gets sworn in and lies? We have paperwork. What would that attorney have added to the case? There's also something said that surprised me. That the fact that there's 11 felony counts here proves the weakness of the case. If reason follows then, if someone murders 5 people, there should only be 1 count of murder? Or if someone does a string of robberies, robs a convenience store and then a 7-Eleven and then a Kmart, should we only charge 1 armed robbery or 1 robbery? No, each action is a separate offense. And as my co-counsel showed you in her presentation, she went through the elements, the dates. These happen on different dates. They actually happen in different buildings. That's why the indictment is specific about where it occurred and the date it occurred. The fact that there's 11 counts doesn't say it's a weak case. It says that it happened over a span of time and with much intent. It was also then asked, or brought up by defense, that the financial disclosure form was not material specifically to this March 16th hearing. Ladies and gentlemen, you'll have the motions that were filed in preparation for that, including the exhibit list, including financial disclosure form, the letter. It was for a motion to regain custody of his kids. How is his financial status and how much he makes not material to the fact that he wants to regain custody? You heard the family expert, the family law expert, talk about how much that influences a judge, about how much a father or a mother makes and how he's able to support. Defense talked about the fact that after the August 31st, 2017 meeting with Hunterton, Nancy, the therapist, when he initially got the letter and it didn't include what he wanted. And the fact that, well, she agreed to it, but then she was out of town. I thought this was interesting. This is State's Exhibit 9, and again, you'll have this back there so you can look at it. This is, you'll recall, the login sheet. And you'll see there on 8/31/17, individual session is what she said the I stands for. He was there. Then he was a no-show, and then a last-minute cancellation, and then there's another 4-month break. So he actually doesn't see her again for almost 7 months. He got what he wanted from the therapist, and then he didn't go back. Month after.
Why couldn't they say it like that when she was on the stand? I was so bored. I missed that complete, because, you know, what does I stand for? I missed that he didn't go to therapy for 7 whole months because the testimony was too boring.
Month after month.
Objection, it's not the evidence.
I'll close with this, ladies and gentlemen. With instruction 5, it explains to you what reasonable doubt is. Reasonable doubt is one based on reason. Doubt to be reasonable must be actual, not mere possibility or speculation. Beyond a reasonable doubt is a high standard, and it is our burden, Ms. Mishler and I. And we invite that burden, and we embrace that burden. The judge talked about, and there's an instruction in there about direct or circumstantial evidence. And defense talked about how there's a lack of both. Ladies and gentlemen, in this courthouse, every week, and in courthouses across our country, juries, much like yourselves, sit in chairs just like that and hear cases and find defendants guilty beyond a reasonable doubt every day in this country. And in many, many of those cases, it's purely based on circumstantial evidence. Because men and women like yourselves go in that room, they talk about it, they use their common sense, they put together what they've heard and what they've seen, they connect the dots, and they find what you will find. That the defendant is guilty. And I implore you, ladies and gentlemen, to go back in that room, put your heads together, talk about what you recall, the language that you heard, not that I just said or the defense counsel said, but what you recall, the people standing on the stand, compare that to the documents, watch the videos, and come back here and tell the defendant what he already knows. He's guilty. Thank you.
Thank you. Swear him in.
You do solemnly swear that you will keep the jury together.
The jury doesn't need to go anywhere. The jury's standing up right now saying, Your Honor, we don't need to go into the room. We're good.
Together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be ordered by the court, except to ask them whether they have agreed upon a verdict, and that you will return them into the court when they have so agreed, so help you God.
I do. Thank you. Ladies and gentlemen, in a minute, you're going to go back to begin to deliberate. We've already ordered you dinner, so we're going to allow you to go back and deliberate. At this time, although you all been here for days and certainly done your duty. The alternates are going to be allowed to go home. That doesn't mean you're released. I've had cases where we've had to call the alternates back because of difficulties. It happens. You have done everything we've asked of you. It doesn't mean just because you're alternates that you didn't, if you will, complete your mission. And sometimes it's a letdown that you don't get to deliberate, but I certainly want to thank all of you for being here. Kathy, the alternates.
Jerome Pollock and Tony Romzik.
You are going to go with Sandy, my JEA, Judicial Executive Assistant. People used to say secretary. In any event, she's going to get your phone numbers, your cell phone numbers, to keep you updated as to whether or not we will need you, etc. So that I want to thank you again for participating. The rest of you are going to go with Steve. As I said, we've already ordered dinner. I want to say one thing which is a little bit different. We're going to let you call anybody you'd like to call if you're going to be, because you are going to be after 5, but I did tell you that before. But after that, we're going to take your cell phones. They'll be in a box outside the jury deliberation room. And the reason for that is, I know that if I don't know a question, I Google it. And I can tell you in very recent trials, I had people doing things they weren't supposed to do. So in order to avoid any problems, that's what we're going to do. It's not Steve, it's me, and it'll just help things go much more smoothly. Okay, go ahead.
Folks, go ahead, grab all your paperwork, grab your notebooks and pens, grab all your personal paperwork, and you'll follow me. Please rise for the
We will
jury.
have the evidence back for you in just a couple minutes.
Oh, I got that.
We made it, guys.
I'm sorry?
May I be heard this morning?
Oh, okay.
I thank you, Your Honor, and I do know that I want to thank the court for attention to the jury instructions. You obviously put a lot of effort into it. I do, however, have to make a couple records on, I would make a record on a couple things. Respectfully, you materially limited, limited my representation of Mr. McDonald. My theory of this case is evolved.
You can be seated. Everybody else is.
My theory of this case is materially evolved since I started this case on Tuesday. Over the years, I've heard just unbelievable stories coming from family court, and candidly, I didn't believe them. I didn't believe most of them, and I didn't believe that the family court apparently is as sordid as it is. When I started this case, I thought it was going to be a very simple case of a little overzealousness by a couple of young officers. I thought we'd get this case resolved as a quick gross misdemeanor, and everyone would go about his ways. Mr. McDonald would be a little bit better with his paperwork in the future. That didn't happen. As the case evolved, the court saw fit to allow the court cameras into that. I've been, for the first time in my career, been on television or been live broadcast since there were cameras in the courtroom. Last night when I left yesterday, I was bombarded with 25 or so pages of people soliciting and offering to help regarding corruption, disease, unhappiness with their family court cases. And going through all the material that was presented as best I could, I found what I thought was the most telling post, which in fact wasn't even known to me this time yesterday, from Mr. Willick's fiance's employee. He claims credit for, and I showed it to you, and you graciously allowed me to go into it. He took credit for this, a post that was anonymous to the detective.
Matches
The
my
detective
heart.
asserted over and over again it was anonymous. In fact, this was a close confederate of Mr. Willett, which brought me to the very stark realization that maybe family court is just as sordid as I believe apparently has been reported to me. There appears to me, since I don't go down there, to be two factions fighting for control of or in constant battle of family court, one of which is led by Mr. Willett and this Nevada Court Watchers. Another one apparently is a group called Court Observers, led by Mr. Steve Sanson and apparently Confederate of Michael McDonald. I say that by background because if I had said this on Tuesday, I would have called myself paranoid. That comment ties this man's thinking between McDonald and Sanson, showing very clearly that there's animus between the two. The detective goes from verifying that Mr. McDonald lives at a location to crawling through his divorce paperwork. I'm convinced beyond any reasonable doubt now that my unfortunate conspiracy theory seems to be actually demonstrably true. Now, when I got up to represent what I had learned over the course of this representation, the court shut me down, and I believe materially limited me. And the other thing that, which I respectfully, this isn't, is if we had civil discovery, you'd have been what we should have done. But this isn't what this case was about.
Jury deliberating right now, so he's just... Don't say that here. He's just talking a lot.
When I got up to complain about the detective's motivations and his insights, they objected that this wasn't a vindictive prosecution case. It appears to be. Having said that, I've got to make my record. You've heard me very politely and firmly. I'm not going to complain that you haven't. Additionally, the other thing that came up was we additionally wanted on, I think it was jury instruction 27, and it follow federal law on ignorance of the law is no excuse. However, on advanced cases where affirmative duties have to be done with compliance of the law, non-knowledge is in fact a defense to specific intent. You compromised and gave us a specific intent, a state law jury instruction, but then the state got up and used the exact same instruction we wanted to have appended and actually placed that on the overhead of our jury. But respectfully, I believe that was an error, and I believe that's going to come back to haunt Mr. McDonald. So I've had my piece, Judge. I'm making a complete record here. I am appalled by what I've seen in the last 24 hours. In fact, not only appalled, but actually fairly dispirited. I've never seen such an outpouring of filth and bile, and I've done murder cases, felony murder cases. I've never seen anything like this. So I don't know what's happened here. I don't understand the detective's motivations or what led the trial, and I'm still not quite sure of exactly who did what and why the presiding judge didn't take this matter well in hand and how he had to become a criminal case. But I believe Mr. McDonald's representation by me has been materially limited, and I have to object and move from this trial.
Mistrial when the jury's gone out?
Record requires me to make a judgment.
It's on the record. Do you want to state?
And Your Honor, obviously the state would oppose the motion. There's been nothing that defense counsel has stated qualifies as a motion for mistrial. I don't want to relitigate all the reasons why a vindictive prosecution is not a valid defense, and Your Honor has denied his motion to dismiss for vindictive prosecution twice now. Regarding his claim that there was alleged error regarding the jury instruction, I believe the jury instruction he's referring to is the jury instruction regarding ignorance of the law is no excuse, and defense counsel never objected to that instruction. He just requested that the additional Supreme Court law be added to that instruction, and Your Honor properly ruled that that was not necessary and declined to add that to that instruction. The specific intent instruction that the parties then all agreed to add was then added as a separate instruction. So the state sees no error that was done during rebuttal by publishing a proper standard jury instruction, which correctly stated that ignorance of the law is not a defense to a crime.
All right, thank you. I'm denying the motion for a mistrial. Not sure at this point that's proper, but in any event, you again have a good argument regarding your version of the facts, and I understand that. But the facts are what the jury is going to decide, whether they believe and this is all based on, I believe, your characterization that the detective started this for some vindictive reason based on being, I guess, influenced to do it by this, whatever happens or what other, the posts, the websites that are deal with family court. But that isn't what the testimony is. He testified clearly. I understand you feel he's lying, flat out. I think that's exactly what you're saying. But that's not what the evidence was, and it's your interpretation of the evidence. The officer said, it started as this, but I found out other stuff, and that led to other things. So I understand your theory, but the facts are for the jury to decide.
Thank you, Judge.
Okay.
Appreciate your courtesy.
When you guys, yes, I'll mark this for you as a court's exhibit.
That was one that came in about 10 o'clock last night. Yes, sir.
Leave your cell phone numbers. And so, those Steve left. We are generally, it's been to 4 or 5. I told you I got them dinner. I probably will let them go till about 8. And so the COs need to tell. I was originally, generally, if we're done, I thought we'd be done by 3. I wouldn't keep them past 7, but of course it's different. So I don't tell them because I don't want them to, okay, well,
Please don't make me.
verdict by then.
Please.
At 8 o'clock, that's it. They will the admonishment, and they'll come back on Monday morning. Any questions?
Ozzy, are you here?
Generally, you can, if everybody wants to come back for the admonishment, otherwise nobody comes back. You understand that? In other words, it's not one side's here while I admonish them.
Your Honor's also report, I have no objections to not coming back.
Okay. That's generally the case, but
That's what we've all done.
so nobody will be here. I'll just admonish them and tell them to be back on Monday. Okay.
That's it. That's at 8 p.m.
Thank you, Your Honor.
Yes.
Okay.
Or, well, I mean, if something comes up, questions, and by the way, if it's just a simple question, I'll try to get you on a conference call. I've had examples in the past, things like, basically, we want you to supplement the evidence, and the parties all agree, that the instructions to be, the court can't supplement the evidence. Go back and deliberate. So anyway, I'll try to get you on a conference call. If not, we'll call you in.
All right, thank you, Judge.
Go for it, Anthony. Fozzie, you created a whole thing in my house tonight. So when I speak to my kids, normally, when I'm trying to remember something, this is sort of how the conversation goes. I'll say to my daughter, oh gosh, what's that song with the guy with the beard? Do, the one with the guy with the beard. And at first, she'll say, Mom, no, we're not doing this again. I need more. You have to give me more than just this song with a guy with a beard. There's no way I'm going to figure it out. Right? And then she'll say something. She'll say, okay, ZZ Top, All Your Loving. She'll say that. And I'll say, no, it's not that. That's not it. That song with the guy with the beard, the one that we heard in the car, remember? Yeah, ZZ Top, Mom, give me all your loving. No, that's not it. So they always get what I'm trying to say with the weirdest, most obscure one sentence. What's that thing? Fozzie asked me a question. the number one gun in Call of Duty. So I'm thinking, I remember my kids playing it. They get on this bus. Zombies come. They open these boxes. So Fozzie asked that question, and I'm like, all right, kids, what is the name of that gun? They all said the same thing. Ray gun. I'm like, no, it's not a ray gun. It's not. It's like a German name, like Hefeweizen. It's like a German name. What is it? And they all started Googling because they had no idea. They couldn't get there. Now they always get there. When I tell them my little facts, they always know what I mean. And today they didn't. But I was sure, I was dead sure that I knew ray gun was not what I was looking for. And they're giving me all types of different waffle things. No. It's not the gun, Fozzie. It's not the gun. Just 5 minutes ago, right before while the judge was blah, 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 I said, Anthony, I know this is from Skyrim, but is it, oh shit, I just said it. Whoa. Fozzie, it's the boss monster's name that I got confused with the gun. Jabberwocky. I said, is it Jabberwocky? Is that the gun? The Jabberwocky you pull out of the box? Mom, no, that's the boss. So, Fozzie, I left stream for I don't know how long, and I don't even know if you guys noticed, because we have been trying to figure out what I was trying to think of for all that time. And Fozzie, Jabberwocky was the word that I was looking for, but it's ray gun. Now we all know. Now everybody knows. Now I can get back to my stream. It's also in Call of Duty. I'm just let down by my kids that they didn't figure it out for me. It's like they don't even know me. Like, who can I trust now?
Remain seated, come to order. Department 28 is again in session.
Guess I'm gonna have to. Yeah.
Case 335284, State versus McDonald. Let the record reflect Ben is present along with Mr. Mueller. I wanted to tell you, they told us they needed a new copy of the verdict form. So the court clerk exchanged the old one for this one. I'm shredding this one. It had notes apparently on it. And so I just wanted to tell you that before even we bring them in. I don't think it needs to be or should be a court's exhibit because there's the statute that the jury's thinking whatever is not part or not whatever.
If you could just throw it in an envelope, Judge, and set it aside, we'll see what the verdict is.
Also in Call of Duty.
This is the one that was rejected. Tell me why I shouldn't shred it.
I think that's fine, Judge, and I have no reason to doubt anything you're saying. I just do know that this is the first time my judge went out of his way to make sure that they instruct the jury that they only have one verdict form and make sure they had it right. And this is the only time they got one verdict form and actually didn't get it right.
It's happened, that's exactly why I do what I do, and it's happened before. And I don't think I'm the only one who only gives them one. But in any event, so that's what I'm going to do. I will inquire, is this your verdict? You'll get the clerk to inquire, and then you'll have them all, if you want to poll them, you'll do that, but that's the official one. Okay, unless you have some reason, it is I'm going to do exactly what I said I would do before, and that's get rid of any duplicates or whatever. If this has and I haven't looked at it, but if it has their thinking, that's exactly what's prohibited in inquiry of a jury panel. So even if I sealed it, it wouldn't be allowed to be inquired into.
That's correct, that is my understanding of the law as well, and we're not allowed to be part of the process of the jury. I agree. Having said that, that's the verdict form we told them not to screw up, and yet they managed to screw it up.
Well, okay. All right, so I am gonna go shred this, and then we'll bring them in, they have a verdict.
Hi, Judge, they're outside the door.
Trying to shred that.
It's just that every day I'm inching closer to dementia. And, you know, I relied on my kids to know what I'm thinking, and they just didn't.
Yes, Judge.
I'm the only one, I paid for my own shredder. The county never gave us a shredder.
How you gonna bring the jury?
Bring the jury in.
Please rise for the jury.
Please be seated. Parties acknowledge the presence of the jury.
Yes, Your Honor.
Yes, Your Honor.
Ladies and gentlemen of the jury, have you chosen a foreperson, and if so, who is the foreperson?
I am, Your Honor.
Will you give us your badge number, your number 1, 2, 3,
Number
5? Thank you. Will you hand the verdict to the marshal? Have all 12 members of the jury reached a unanimous verdict as to the charges presented to them?
Yes.
Thank you.
Yeah.
Clerk will now read the, please rise. Clerk will now read the,
District Court.
That's what I'm saying,
Yes.
yes.
Michael McDonald. Case number C-335-284, Department 28. Verdict. We, the jury, in the above entitled case, find the defendant, Michael L. McDonald, as follows. Count 1, burglary, guilty of burglary. Count 2, forgery, guilty of forgery. Count 3, offering false instrument for filing of record, not guilty. Count 4, burglary, guilty of burglary. Count 5, forgery, guilty of forgery. Count 6, perjury, guilty of perjury. Count 7, offering false instrument for filing or record, guilty of offering false instrument for filing of or record. Count 8, perjury, guilty of perjury. Count 9, burglary, guilty of burglary. Count 10, forgery, guilty of forgery. Count 11, offering false instrument for filing or record, guilty of offering false instrument for filing or record. Dated this 9th day of September, jury fourth person. Ladies and gentlemen of the jury, are these your verdicts as read? So say you one, so say you all.
Yes.
does either party wish to have the jury individually polled?
The defense would ask that they be individually polled, Your Honor.
Poll the jury.
Juror number 1, is this your verdict as read?
Yes.
Juror number 2, is this your verdict as read?
Yes.
Juror number 3, is this your
You mad,
verdict
bro?
as read? Juror number 4, is this your verdict as read?
Yes.
Juror number 5, is this your verdict as read?
Yes.
Juror number 6, is this your verdict as read?
Yes.
Juror number 7, is this your verdict as read?
Yes.
Juror number 8, is this your verdict as read?
Yes.
Juror number 9, is this your verdict as read?
Yes.
Juror number 10, is this your verdict as read?
Yes.
Juror number 11, is this your verdict as read?
Yes.
And juror number 12, is this your verdict as read?
Yes.
Verdict of the jury shall be recorded in the minutes of the court. Ladies and gentlemen of the jury, I want to thank all of you for participating. You've paid attention. You've spent now a week
Will be done, God.
here, and we appreciate your efforts and all your work. You are now released. You can now talk to anybody you want about the case. What we're going to do is, Steve is going to take you back to the jury deliberation room. I want to shake everybody's hand and thank you again. If afterwards, a lot of times the attorneys want to ask you questions, it's always a learning experience for everybody. Every trial is different. If you want to answer their questions, feel free to do so. It'll be outside. If you don't, Steve will take you, go right down stairs to your cars. Again, we appreciate all the hard work, and I want to thank you. Go ahead.
Please rise for the jury. Come on now, here we go.
Matter is referred to the Department of Parole and Probation.
It's not, because there's this slim, tiny little chance that one of the jurors is going to say, you know what, no, I didn't want to do that. It's a slim, tiny little chance. And then that's it. It's all it takes is one juror. And it only takes, I mean, he's already guilty. So they have nothing to lose by saying, pull the jury, pull him.
Sentence report and set up for sentencing.
October 30th at 9 a.m.
Is,
Mr. Mueller pulled him out here, Your Honor, so. You want to have him come back in?
well, Mr. Mueller needs to be here at least, so we can give him the date.
Yeah.
No sentence
Mr.
today.
Mueller, we set it for sentencing, and the date was?
October 30th at 9 a.m.
I can't remember what it is, but I think I got something that day, but I'll be ready to go. I've got lots of post-trial motions to file to not get repeatedly, you know, my view on this case. I'm very disappointed in that verdict.
Okay. So you got the date? Did you say you can't do that day?
I don't have, I was looking on Las Vegas, I didn't get my calendar, so I'll leave it on calendar. Just,
Okay.
We'll have you some
All right,
post-trial
thank you.
All right.
Tim, the tool man Taylor. We stayed late to get to the verdict, but we didn't get the sentence. We will. We'll figure it out. There's another video. It's coming. Oh, sugar. No, this is just... No, this video is one of those other ones. Alright, guys. I didn't set OJ up yet. I'm going to set OJ up and see some of you there. And I will see the rest of you tomorrow. Thank you so much for coming out today. I'm sorry about the long lumberjack story, but it disrupted my whole stream tonight. So I told you about it. I'm going to get in trouble for that in the comments. People are going to complain that I talked. But that's okay. I can't, Fozzie. I've already missed 2 days. See? So I'm going to put on OJ for like an hour. See you guys real soon. Thank you for coming out. Bye.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps. world turns gray. With a giggle, she lights the way. Kathy's life.